Good morning. Welcome to everybody. My name is John Mayo. I am a professor of economics, business, and public policy at the McDonough School of Business. And I'm also the executive director of the host for today, the Georgetown Center for Business and Public Policy. We are thrilled at this moment to be able to host this, let's call it first impressions of the new merger guidelines, the proposed new merger guidelines discussion. We think it's going to be a very rich, robust, fulsome discussion that we'll all benefit from. And we're very excited about it. Just so that everyone knows the sort of flow of the event for today, what we're going to do first is hear from the agencies. First from David Lawrence, who is the policy director for the antitrust division of the Department of Justice. And then we'll hear from Aviv Naveau, who is the director of the Bureau of Economics and on leave from the University of Pennsylvania as professor at the Wharton School. We'll then move to a panel discussion. We have a marvelous, wonderful set of antitrust experts for a panel. We'll first hear from, or I'm not sure what order we'll actually hear from them in, but Deb Garza, who is a partner at Rule, Garza, and Howley. We'll then hear from Diana Moss, who is the president of the American Antitrust Institute. And last but certainly not least, my colleague Howard Shalansky, who is a professor of law in the Law Center at Georgetown University. The panel will be moderated by my colleague, Mark Whitener, who is an adjunct professor in the McDonough School and is a senior policy fellow at the Georgetown Center. Now, that discussion, we're aiming to end right at about noon. And as much fun as that's going to be for the first hour or so, I think it's going to get even more interesting. And that is what we're going to do is ask you to recess from this room, go out the door, and either left to the elevator or down a set of stairs on your right to a set of sandwiches. The sandwiches aren't the exciting part, but sit down there, grab a few bites of a sandwich, talk amongst yourselves. And then as you get going, we're going to open it up to a set of discussions, questions, comments from you. We have a lot of antitrust expertise in the room today. So this is a marvelous opportunity for first impressions to be shared. And we just think is going to be wonderful. We have a very full agenda for today. So without further ado, let me ask Dave Lawrence to open things up, please.
Great. Well, thank you so much for the kind introduction and to Georgetown for hosting us. The last time I spoke at one of these events was actually the version we held on the vertical merger guidelines. Let me just say how happy I am to do this in person, where we have debates, but also sort of empathy and understanding. As then, I have to start with the disclaimer that I'm speaking only in my personal capacity, and these aren't necessarily the views of the DOJ. I do know I speak for the drafting teams at both agencies, though, when I say we are thrilled, absolutely thrilled to begin the comment process and hear from all of you. Welcome inside the tent. That's really the most important thing I can convey this morning. We're approaching this comment process with deep appreciation and humility. First, we appreciate the engagement of the broader antitrust community in this project. By being here today and joining in the debate, positive or critical, you will help us make the guidelines the best they can be. I also have to share my appreciation for the work that came before. The 2010 guidelines that Howard, Carl Shapiro, Joe Farrell, and others prepared were a tremendous advance. The new draft stands on their shoulders and those of guidelines drafters going back decades. I will say that's true as to the 2020 vertical guidelines as well. I served as AAG Macon Delrahim's lead in that drafting project, working closely with Bilal Sayed and a talented team at both agencies. And for those who haven't noticed, I'm delighted to say those guidelines have survived in the form of Guideline 5 in the draft, and then, of course, the efficiencies rebuttal. As I said, we also approach this project with humility. Above all, humility as to our role as law enforcers. Our authority. So I've worked as a counsel or lead advisor to 7 AAGs and 3 administrations. Everyone's authority to prosecute depends entirely upon their faithful application of the law passed by Congress and interpreted by the courts, not the executive. The guidelines are not the law and cannot try to be. What merger guidelines must be, however, is a transparent source to which the public can turn to understand how we undertake our merger analysis, so that the 97% of transactions that move through quickly, a business person can read and understand. It's a document that fosters predictability and consistency. To do that most effectively, I believe guidelines should reflect both of the two key elements of our merger analysis, the law and the economics. We are most transparent and effective when our guidance documents connect the binding precedent in this country to modern economic and analytical tools. Many of you, I'm sure, are familiar with the 2000 antitrust guidelines for collaborations among competitors. That's an example of this approach. They cite binding holdings of the Supreme Court, only the Supreme Court, and then connect them to modern economic and policy principles. I'll say in the merger context, we found it hard to draw the line the competitor collaboration guidelines do and stop at Supreme Court precedent. How could we have a modern presentation of merger law without DC Circuit opinions like AT&T, Time Warner, and Baker Hughes? So we included those key precedents, and this document, for the first time, is structured around the burden shifting framework. I'll say we also closely examined district court decisions to ensure that the binding precedent in this nation had not somehow expired. We found that every district court deciding a federal merger challenge in the last 3 years has relied on Brown shoe. 11 out of 11. All told, it has been cited by at least 50 district courts in the last decade. And just this month, the Third Circuit affirmed a district court decision that rejected a guidelines-based analysis in reliance on Brown shoe. That's if you go back and read the Sugar opinions and our appeal. The DOJ lost the Sugar case in part because of our reliance on the 2010 guidelines rather than Brown shoe. Philadelphia National Bank, General Dynamics, they're not far behind with dozens of recent citations each. And I'll include in my published remarks the string cites to this nearly 100 cases. So we knew that the Supreme Court seminal cases had to form the bedrock of the guidelines. But we also know that much of Brown shoe's economics are outdated. And in many respects, they're just plain wrong. The economics in many older Supreme Court cases is regrettable and forgettable. Yet the holdings of law survive. This is familiar to any antitrust lawyer who's an expert in both the cellophane fallacy and the many citations to DuPont that are still relied on today. Drafting the guidelines, therefore, presented the same challenge that division and FTC face in every federal court. How do we present modern economics using older binding precedent? How do we bridge the gaps between the law and the economics of merger review? I don't have all the answers to those questions today. I will say they are the questions I am most excited to get answers to in the public comment process. It's what we've attempted to do in the draft. Let me finish with just a couple examples before passing it to Aviv. So first, do the guidelines apply the best framework for considering rebuttal evidence? The rebuttal section, this is section 4, it follows general dynamics to, quote, examine any other pertinent factors that show no substantial lessening of competition is threatened by the merger. That key section in the draft cuts back sharply, to use the words of Baker Hughes, the prima facie frameworks in the draft. And both the prima facie and rebuttal sections then draw on the appendices for the all-important tools of analyzing competition in particular cases as you move through the burden shifting framework. So I am particularly interested to hear if the rebuttal section and appendices sufficiently empower the use of the best available economic tools to sort pro-competitive from anti-competitive transactions under the law. Relatedly, I look forward to feedback on the framework for the evaluation of efficiencies. I know we had many, and we read them all, commenters who opposed including any efficiencies defense or recognition of the concept. I'd ask them to consider whether accepting an efficiencies rebuttal at step 2 of the Baker-Hughes framework, as the guidelines do and circuit precedent suggests, is consistent with the law. I'm also interested to hear from those who emphasize the importance of efficiencies, whether the approach in the guidelines of focusing on pro-competitive efficiencies, broadly defined, sufficiently opens up the analysis to innovation and other dynamic competitive effects from mergers. Our hope is that by examining how competition plays out in each case, both the pro-competitive effects and anti-competitive effects of a merger, as the statute requires and the guidelines describe, we can better and more comprehensively consider both the risks of harm and potential benefits of proposed mergers. Okay, I have a lot more questions and I can't wait to hear your feedback, but I'll stop there in the interest of time. If you can't tell, we have worked really hard and thoughtfully on this draft, and we are incredibly eager to make the final the best it can be. That means ensuring it is transparent and accessible, and that it does justice to both the law and the economics of merger enforcement. Your comments are going to help us do that, so let me thank you in advance and pass the microphone to my colleague, Aviv.
Thank you, Dave. So first, I'd like to thank John and the Georgetown Center for inviting us and setting this up. This is a great event. The usual disclaimer, what I'm about to say are my personal views and do not reflect the views of the commission or any individual commissioner. So I'd just like to second basically everything that Dave said. And part of me just wants to say, hey, I agree with him and just sit down and get the comments. I'll say a little bit more of that, but not much more than that. So let me just kind of talk about a few points briefly, although again, I could go very long even on just the points that Dave talked about the legal side. I could add the economics, but I think I'll try to keep that very short. So first, I'd like to stress the importance of where Dave just finished, talking about the rebuttal evidence generally and specifically about efficiencies. I think Dave sort of laid out the legal side of it very cleanly. I think there's kind of very clear economics behind what we're trying to do. That being said, you know, we do have some work to do, and I'm sure that's going to come up, you know, during today's discussion and more generally in comments. And that's what we're really looking forward to, is to get comments on exactly the places where we need to clean up. And this is a draft, the one that we know we still need to do work on. There is some cleanup we need to do. Specifically, let me talk about actually a case where, even though I'm just mentioned rebuttal and efficiency, let me actually go back to one of the guidelines. So let me talk about guideline 1. Okay, this is the guideline that talks about the structural presumption. So I've heard a lot of concern that this has no economics and just purely sort of arbitrary thresholds, and there's really no economics to them. I don't think that's the case, and I'm not going to make kind of a full argument in the 2-3 minutes that I'm going to talk about it, but let me just say kind of the logic of what I see is going on here. Guideline 1 creates a presumption. Frankly, in practice, very much like 2010. Okay, we're maybe changing the numbers, but in practice, the way we're proposing to use them, as Dave sort of alluded, how courts are referring to them, there's very little change here. Again, besides changing the numbers from 2,500 to 1,800. I want to stress that the way we've sort of set this up, there's a presumption, but it's a rebuttable presumption. Okay? How do you rebut it? You can do a variety of different things. You can go and challenge that the agency's got the market definition incorrectly, right? And how do you rebut that? Well, most typically in a case like this would be by saying we got the hypothetical monopolist test wrong, and therefore the market that the agency is proposing is not correct, right? That will involve economics and looking at economic evidence. An alternative that you could to rebutting this is to come and say, yeah, that is a market, that is the thresholds, but they're not indicative of the lessening of competition that would arise from the merger. How do you challenge that? Well, you could do it in a variety of ways, but I think the one that probably makes the most sense is to actually put forward an economic model and try to argue that in this particular industry, using its market realities, that economic model is a better prediction than the threshold. That is a type of evidence that you could put forward in front, even in the investigative stage. We will sort of look at that. The agencies will look at that. Okay, and maybe that wasn't quite as clear when we look at the rebuttal evidence. Maybe that's something we need to clarify. So in a way, it's not saying there's less economics. And by the way, I think, standard economic models, you don't have to go back to the so-called structural conduct performance paradigm to justify the concentration threshold. Okay, standard Bertrand, Cournot models give you generally a correlation with, as there's higher concentration, you get worse outcomes. Okay, they're not exactly saying it's HHIs and not exactly the numbers, but you do have that effect. So the point is, there's going to be economics. It's just going to be introduced here and kind of maybe slightly different sequence. But in practice, I think very little change to what I see happening today. And frankly, the cases where I see the agencies going to a purely structural case, not relying on economics, are really the very extreme cases. Cases like, for example, the Williamson merger that I was involved in, that post-merger, it wasn't really this. I mean, the argument there was whether post-merger, the merging party will have 60% market share or 85% market share. Okay, with the rest of the shares basically being very, very small firms. Okay, that was the argument. That's not the type of argument that we should be wasting courts' time trying to dispute. Okay, those should be fairly easy cases. And those are the ones where I see going purely on guideline one. So that's a way in which I actually see there's going to be, at least as much economics as before. Let me just conclude by just saying one other thing that I've heard over the last few days of people sort of claiming that there's less economics in these guidelines. And there's kind of an argument that, well, a lot of the economics has been relegated to the appendices. Okay, I honestly don't understand that comment. The appendices are an integral part of the guidelines. If it helps someone, we could label them section 5. Okay. I don't see how that would make a difference, but if someone thinks that that will kind of ensure that they are seen as an integral part, I think that's something we should consider. The appendices, yes, that's where they contain a lot of the economics, because I think it makes it the document much more readable. And I don't think that there's any argument that they are an integral part of these guidelines. So let me stop here, and I look forward to hearing the comments. Thank you.
Okay. Aviv, David, thank you very much for kicking us off. So now for the next few minutes, we're going to have our esteemed panel engage in a little bit of a dialogue around the guidelines, comments we've just heard. We're going to start with each panelist taking 3 minutes or so for some opening remarks. We'll go sort of down the line, starting with Deb Garza. And then after that, we'll have a little bit of a guided discussion among the panel, and then David and Aviv will come up at the end of the hour for some closing remarks. Then we'll move outside or downstairs to lunch. So let's start with our opening 3 minutes or so from each of you. Deb, why don't you kick us off?
Great, thanks. And you can nudge me or say something if I've gone beyond. So a pleasure to be here. Thank you for inviting me to this panel. I want to say at the outset that I have a tremendous amount of respect for David and his colleagues, and Aviv and your colleagues. Tremendous amount of respect for Susan Athey. And also, having been involved in a number of guideline projects myself, I appreciate how difficult it is. It's a difficult task. And I also appreciate your willingness to put it out for public comment. That's not always been the case, and it's hard. And I appreciate your comments. I do think, well, I'll get into my comments. That having been said, I'm going to be a critic. You've said that I think you can take it and give it back to me. I do. That's what I'm going to say are my first impressions. And I think it's important to say it's the message that I think a lot of people in the bar and the business community have received. Language is important. Rhetoric is important. I know we used rhetoric at the time of the 1982 guidelines to try to shift the law. I think my perception is that these guidelines in some respect are an attempt to shift the law again, shift it in a different direction. And so language matters, and maybe you will have an opportunity to put a gloss on what we see. But in terms of first impressions, To me, the proposed guidelines are substantially a throwback from their heavy citation to cases decided in the 1940s, 50s, 60s, and 70s, not based on economic principles that are sound, that we think of sound today. You said, I think it was David, you said that, Brown Shoe really doesn't appreciate modern economics and got it wrong, but it's cited in all the briefs, it's cited in opinions, get that. But I think in a way that the guidelines are put, there's a perception that the reliance on these Supreme Court cases combined with a lot of other things that the agency said are meant to push the law back. So it's the citation of the cases, and then it's the embrace of standards that we haven't seen used since the advent of modern merger guidelines. And I'll get into a little bit about what those are. The perception is that the guidelines signal a return to big is bad ideology that underappreciates both the pro-competitive potential of mergers and the damage that an overly restrictive approach to merger control can do to the economy and to the competitiveness of U.S. firms and global markets. There's no acknowledgement in the guidelines that most M&A doesn't raise significant competitive concerns. David, you mentioned at the podium that I think 95% of transactions don't raise concerns. There's no acknowledgement in these guidelines, unlike in prior guidelines, that that's the case. Instead, it looks like 101 reasons why your merger is bad. The merger guidelines from 1982 through 2010 and 2020 each attempted to articulate a nuanced approach to merger enforcement that was consistent with the case law, based on sound economic principles and consciously designed to catch those transactions that posed a serious threat to competition and consumer welfare, while not impeding the vast majority of transactions that don't pose such a threat. I personally think the Biden administration could usefully have added to those guidelines, to 2010 guidelines, with its discussion of mergers involving platforms, the ecosystems issues. There are certainly a number of areas that were not addressed in the 2010 guidelines that you could usefully have added to. And I think that those sections of the guidelines that are most useful, of your draft guidelines that are most useful and enduring part of the guidelines, are those dealing with platform issues. One more minute. Okay. So I'm going to, in 1 minute, here are my 7 headlines. Strict structural presumptions at lower levels of concentration. A market of 10 equally sized firms will not be considered concentrated. Get into that a little bit more. A renewed emphasis on potential competition theories, both actual and perceived potential competition, based on the statement that the antitrust laws reflect a preference for internal growth over acquisition. Conglomerate concerns. Would the merged firm be able to leverage its position in one market into another by tying or bundling? That's a significant aspect of these guidelines that I don't think we've seen in prior guidelines. Labor markets. Challenging labor market effects appears to be an administration policy, a priority. I think we should expect unions to be at the table. We should be aware of efficiencies based on closing plants or other reductions in labor force, even if consumers would benefit from production efficiencies. Multi-sided platforms. As I mentioned, platform company acquisitions will continue to face heavy scrutiny. The guidelines explain the agency's general approach. Serial acquisitions. This section takes aim implicitly at PE firms and so-called roll-up strategies. The agencies are going to look at both consummated and proposed deals and the firm's overall strategy. That's new. That's not something we've seen in other guidelines, and I have some issues with that. Efficiencies, not considered to determine a merged firm's incentive to raise price or reduce output as under the 2010 merger guidelines, which I found to be very useful. But now it's a rebuttal. The way the document reads, a rebuttal you will never be able to make successfully at the agency, at least. In addition to verifiability, pass-through merger specificity, if input prices are expected to decrease, cost savings will be treated as an efficiency. If they reflect and won't be treated as an efficiency if they reflect an increase in monopsony power. Or if the efficiencies signal that there's going to be, that they may accelerate a trend toward concentration or vertical integration. So this tells me that how your claimed efficiencies, this is an example of how your claimed efficiencies are not going to be a successful rebuttal, but may actually become another basis to challenge the merger. So the efficiency section, as I read it, is substantially changed from what was until 2010. And I think it's kind of a scary change that's been made that really will discourage companies from coming forward with efficiencies. There's no comfort for me that the efficiencies are going to be considered. Okay.
Dan?
Are we on? Yes. Yes. Hello, everyone. Many thanks to John and to Mark for inviting me here today and being part of this great discussion. It's really an honor and a pleasure to be here. I want to give you 4 major first impression takeaways from my read of the revised guidelines. One is on the bigger structure of frameworks and then applications approach. Second will be comments on what I perceive to be a rebalancing of legal doctrine and precedent with the role of economics, which I think is a response to quite a bit of concern about economics hijacking antitrust analysis for many years now. Third, I want to mention that I think the guidelines inject needed guidance on mergers that are occurring at a time of great concern over rising concentration and declining competition. So there is your response in the guidelines to what we've seen over the last 20 or 30 years. And then finally, how judges might view these guidelines and how they might implement them as they move forward. Okay, so back to number 1, frameworks and applications. The approach makes a lot of intuitive sense, right? Here are the 1 through 8, which are the major ways that would raise concern about how firms compete. The guidelines are really threaded through with this notion of how do firms compete? How would they compete in a post-merger world that would raise concerns about a substantial lessening of competition, right? So that all makes sense. The applications are interesting. So that's guidelines 9 through 12. We've got something on monopsony, multi-sided markets, serial acquisitions, and partial acquisitions. I do wonder how these applications were chosen and whether it's an exhaustive list of applications for guidelines 1 through 8, or whether there are other potential applications that the agencies might worry about. For example, what about what we call systems competition, where we now have vertically integrated monolithic companies operating in healthcare and agricultural biotechnology? I'm talking traits, seeds, agrochemicals, where the mode or the paradigm of competition is shifted from competition within a system where smaller entrants can get in and compete at a particular level versus competition between these monolithic systems. I think that is another application that I would have hoped the agencies would pay attention to. Number 2, rebalancing legal doctrine and precedent with the role of economics. This is a big thing. And again, the guidelines are laced through with this rebalancing, which is I think, designed to address the concern that economists have taken over and legal precedent plays little to no role. Interestingly, the guidelines cite how Section 7 is the first line of defense against tacit collusion, right? Can't get to tacit collusion under Section 1 very easily anymore. You need smoking gun evidence of a conspiracy. So Section 7 is really the first line of defense. AAI has been saying this for years. The guidelines also say that you can get to mergers under Section 2, right? Acquisitions, serial acquisitions, for example, by large digital platforms, and also in the non-digital world. Look at Autodesk. Autodesk has been on an acquisition spree for years, acquiring their way to dominance in the building software industry. So I think those are very important. Lots of cites to Supreme Court law. That gives judges, I think, something to rest on more comfortably as they are increasingly faced with complex economic modeling and analysis in their courtrooms, right? However, I went through the guidelines and looked at all the references to the circuit court law, which is really where the district court judges are going to be going for their indicators of how they're going to view and ultimately rule on merger cases in their district courts. A lot of cites to district court law, but really on non-controversial factors, stuff nobody would really argue with. Things like, yep, in a vertical merger, the company has every incentive to maximize the profits of the multi-product firm, right? Intentions for merging. Don't take executives' word that they're going to act nicely and they're not going to act to restrain competition, right? Other examples of circuit law citations that are sort of no-brainers. Yep, foreclosure is definitely a a concern in a vertical merger. And the list goes on, but there are not many citations to controversial circuit law that district court judges are going to need to go to be able to implement these guidelines in the best way that they can. Okay, number 3, I know I'm running out of time. Injects needed guidance on mergers occurring at a time of rising concentration and declining competition. Very happy to see the consumer welfare standard remains intact. We were very worried about that at AAI as a center left organization, that we might be looking at a public interest standard as opposed to a consumer welfare standard. But kudos, I do think that the consumer welfare standard is approached and will be interpreted as flexibly as possible. Price and non-price effects on the competitive effects side, on the efficiency side, looking at short-term static efficiencies, longer-term dynamic efficiencies around innovation, et cetera. So very curious to see how that's going to go. We have 2 new structure. We have a rephrased, revitalized horizontal structural presumption. We have a new vertical merger presumption. That is, I think, a direct response to concerns over declining competition. We have a willingness to consider what I'll call non-static analysis. That is the trends towards concentration and patterns of serial acquisitions. That is obviously a response to rising concerns. I think we have more clarity now on potential competition showings, reasonable probability of market entry, as opposed to, you have to prove that the firm would have entered, the potential acquiree would have entered but for the transaction. Allowing for direct evidence as proof of defining markets or market power. And we see for the first time outside of the Section 1 context, looking beyond market structure to these plus factors, especially in vertical mergers. I think that is new, and that signals a willingness of the agencies to really consider a full complement of evidence. And then finally, really shutting down escape hatches for defendants. Executives would never behave badly. A rejection of out-of-market efficiencies, been waiting to see that for many years now. So good move. And an official adoption of the pass-through requirements on inefficiencies claim. We saw that in Heinz, but it has really never been strongly codified in agency guidance. And then finally, I just want to make the point that if we're going to make it easier for judges to deal with these new guidelines, I think it would be helpful, maybe on the last round, to consider giving judges more than just case citations, giving them examples of how to apply these guidelines to avoid past antitrust Armageddons. So Live Nation Ticketmaster, that's an antitrust Armageddon. AAI just came out with a commentary which we have advocated on now for 20 years, saying that was a presumptively illegal merger. Should have been blocked at the time, was not, has now gone through 2 rounds of consent decrees, which continue to be ineffective. Why are judges not being presented with examples of how to apply these guidelines to avoid antitrust Armageddons, right? How about agricultural biotechnology? We used to have 6 ag biotech competitors 10 years ago. Now we have 3. They've all merged together, and it has affected everything from innovation on genetic traits to how they compete on technology prices for farmers. So I think if you're going to use case citations, I would absolutely consider using examples of what judges could avoid in the future in applying these guidelines. And that also goes to efficiencies claims, where there is now a mountain of evidence on how past mergers, not all, but some past mergers have failed to really prove up the efficiencies. That's powerful evidence for judges to consider when they are applying these guidelines. And I will stop there.
Okay, great. Thanks. Howard.
Great, thanks very much. It's always a pleasure to be on a panel with Diana and with Deb, and thanks very much for having me. Just a couple of comments. So there's some things I really like in these guidelines, and there's some things that I don't like, and some things that raise questions. I like the more integrated approach. I think it's important to not silo horizontal, vertical, conglomerate effects. I think that often the line amongst these different effects is unclear. I would appreciate a little bit more definition on what a conglomerate effect is. I have ideas about that. I think a lot of people have ideas about that. I'll come back to that in a moment. I like the expansion of approach to coordinated effects, something I think some of us wanted to do in 2010. I think the
prevailing environment wasn't open to that. But I very much agree with Diana's point that the real line of defense for a lot of coordinated effects that don't rise to the level of collusion is Section 7. Judge Posner understood that in the 1980s in Hospital Corp. And it seemed to go away after that. I think he said something like coordinated effects are the sine qua non of merger enforcement. And of course, if you go to a more concentrated market, you have a good chance of getting these. But Posner, one should also remember, sort of wanted to find a way to get at tacit collusion under Section 1. And, there just wasn't a way to do it. And he sort of saw Section 7 very much as a way to approach that. So I appreciate bringing that back in. It's one area where I think the very structural approach is important. Coordinated effects are extremely difficult, very difficult to prove. The factors limit the conditions under which they can arise. I think you're going to yield some good dividends. I also appreciated the continued building on unilateral effects. To me, unilateral effects were one of the big achievements of the 1992 guidelines. I felt like in 2010 we did a lot to sort of make more specific how you show unilateral effects. And if you were to ask me what the biggest single accomplishment of the 2010 guidelines was, it was getting past the sort of Oracle PeopleSoft rule that you needed to have sort of a monopoly market share before you could show unilateral effects. And we did it, indeed see in H&R Block and some other cases after the 2010 guidelines that they had the desired effect. So I appreciate the building on that. Two specific provisions of these guidelines that I will use as examples of where I think there needs to be some further explanation. Aviv, I very much appreciate your defense of Guideline 1. And so long as the Honorable Niveau is always present to interpret and help the agencies decide how to apply Guideline 1, I feel like we're in good hands. But I feel like as drafted, Guideline 1 does really feel like an institutionalization of Philadelphia National Bank in the guidelines. Not coincidental that the line is drawn at, the alternative guideline is drawn at 30% plus, a 100-point change in HHI. The word impermissible is used in Guideline 1. That, mergers that go beyond this level of concentration, 1,800 plus, 100, 30% plus 100, are impermissible. Now, it may be that they're impermissible unless rebutted, but impermissible is a pretty strong word. And impermissible, I think, will communicate to people that, well, you might ultimately prevail in rebutting the prima facie case before a court, but the agency is going to really run with this. So I do think some further explanation about how rebuttability factors in and clarification that you really do mean this as a presumption, because if you read that and immediately have sort of either nirvana or PTSD in seeing Philadelphia National Bank flash before your eyes, the word undue concentration. The court didn't have to look at anything beyond that concentration level. Later there was pushback on that sort of approach in General Dynamics, which is again cited here. I think pulling that back together and further explication would be helpful. One editorial comment, I don't view the change from 2,500 to 1,800 to be consequential. It's a nice signal. It didn't have any impact. If you look at enforcement, Carl Shapiro and I did a paper that looked at merger enforcement in the decade before 2010 and the decade since. If anything, there's a statistically insignificant decline in the HHI level at which mergers were challenged in the years after it was changed. So I guess one question is 1,800 signaling, 1,800 and we mean it this time? Or, so just some more discussion there. The other provision I want to point to has to do with upstream buying power. Very important. Look, I think, Peter Carstenson's been yelling at us for decades that we've underappreciated the importance of monopsony, particularly in agricultural markets. Peter's right. I think if you look at what's happened, and Diana cited a couple of the market developments that are important. The upstream buying power is not a monopsony provision. It's really about upstream buying power and harm in those upstream markets, depressing prices or depressing wages, disconnected from what happens downstream. So that sort of severs the relationship, if you ask me, to a coherent monopsony theory. So Diana has praised this, I think, don't let me put words in your mouth, as being an explicit recognition of not accepting out-of-market efficiencies, where you say in that provision, if you have buying power for labor or another input, we're not going to let you justify that by downstream product market efficiencies. I think one might be able to justify that, as the guidelines tried to do, with the textual analysis of Section 7, any line of commerce. On the other hand, I think it is a heavy lift if somebody can come forward and say, we are getting buying power in the upstream market, we are going to pay less for labor. We may get that by virtue of a technological change that's going to make us need less labor. So in needing to buy less, we, by definition, create a supply imbalance that gives us some buying power in that upstream market. But there is zero impact downstream. In fact, we can prove to you the downstream product market is such that we have to pass all these things through and consumers get better pricing. Here is my question. I don't know if it's doctrinal, philosophical, metaphysical, or a whole lot of other words that I don't know the meaning of. But is it a harm that is cognizable under antitrust law that workers are getting lower wages without a connection to downstream monopsony effects? I think that's a very important legal question. There is no question that workers getting lower wages is a problem. It is an income inequality problem. It's a labor market problem. It's a public policy issue to be addressed. But if it is not an antitrust problem, then it is not a Clayton Act Section 7 problem. And the harm to a line of commerce that you are protecting against upstream there and disallowing a downstream efficiencies defense to is not a cognizable antitrust harm. And I think you will lose cases. So I think there needs to be some explanation of what you really mean by upstream buying power, labor, or any other input. And do you really mean that disconnected from downstream product market effects, it is in itself a cognizable antitrust harm? I think more clarity on that's going to be important. And I will signal if the answer to that is yes, and I will take seriously the speeches I've heard from administration officials suggesting that is what you mean, that is a fairly radical departure. And I think it just needs to be recognized as such. So I'll just throw that out as an observation and sort of a question and my remarks there.
Okay. Oh, thank you. Okay. So the best laid plans, I have a whole menu of follow-up questions, which we don't have time for. But I think
plan was to derail those.
Yeah. But I think this was extremely useful. You've covered many of the things I wanted to touch. So let me circle back. I had 3 questions. I'm going to fold them down into 2 if I could on the fly. The first was going to be to talk a little more, Diana, about your idea that there is a trend in the economy toward concentration, fueled in part by mergers, fueled in part by presumably anti-competitive mergers that have been allowed to proceed by previous policies. Those premises were all stated, I think, essentially in the agency's RFI setting up this product. And I think it's fair to say directionally, if there's a movement in policy, it's toward somewhat more aggressive enforcement, somewhat more skepticism about efficiencies. If those are fair, is that premise well-founded that a move toward more aggressive enforcement is needed? And secondly, how, if at all, will the guidelines do that? And I want to ask each of you to address both horizontal and vertical merger enforcement, if you could. So, do we need new, more aggressive policies toward mergers? And will these guidelines actually bring that about in both the horizontal and vertical sphere? And perhaps Deb was going to lead off on one of those questions, and Diana on the other, so I'll open it to either of you to start with.
Well, I'm happy to start this off. I think you can't deny that there is a rising level of concern about growing concentration in key sectors in the US economy. AAI is an organization that we're not a grassroots organization. We do hear from workers and consumers all the time, but we also hear from major participants in the supply chains that are on the receiving end of anti-competitive conduct that's designed to limit their ability to compete. So small businesses, and these days a small business could be something like PayPal. Let's face it, right? That's really a smaller type of business. So there are grave concerns about the ability of smaller rivals, entrepreneurial firms wanting to get a foothold in the market and stay in the market to compete. And if you pair that up with mounting economic evidence of rising concentration and effects on price levels, on wages, on disparities between measures of equality in the economy, I think there's a legitimate case to be made for why we should be really focused hard on doing everything we can to maximize enforcement of the antitrust laws. And I think that's what the Biden folks have stepped in to do. I do think that the Biden administration has retracted to the middle ground, right? The people who are going to object the most to these guidelines are the far right and the far left, because as far as the far left goes, they don't go far enough. As far as the far right goes, we need to really give a lot of deference to the benefits, the efficiencies of consolidation, and some restrictive practices. So these will appear. These guidelines will appeal to the middle ground. But that's what wins elections, right? Middle grounders are the ones that are out voting and winning elections with enough heft to be able to swing the outcome. So I think that's a response to Mark's question. Do the guidelines achieve this? I think they do in terms of modernizing and clarifying and strengthening. But again, this is all going to end up in the courts, and we are already seeing some interesting developments in the courts under the Biden enforcers, and there isn't much time left.
Yeah, middle ground.
Well, so look, I consider myself in the middle, maybe a little bit to the right. I don't consider myself to be far right at all. And I'm a former enforcer, and we brought cases, and I believe in antitrust enforcement. So I do view myself as the middle. I think you and I are, maybe you're just a little bit to the left and I'm just a little bit to the right, but we agree on a lot of things. Yeah. Well, that's right. But that's very appropriate, because I think we are often more in agreement. But so that having been said, these guidelines definitely reflect the Biden administration's view, which has been expressed over and over, and which Diana, you've talked about, and Howard, you talked about. I mean, there is a perception in this administration that the past policies are failed policies, including in the Obama administration and even in the Petoskey. So there's clearly an attempt here in the guidelines to follow through on a policy that says we have to change the way the game is played. So that's why I say the messaging of these guidelines is definitely, to me, let's get tougher. There are some aspects of the guidelines that I think are a little far out there. I mean, the potential guideline 4, the potential competition merger. We don't have time to go through it, but I think there's a lot of issues there, a lot of problematic areas there. Guideline 8, the trend toward concentration. I hear Diana when she talks about why that's a concern. Look at the guidelines. I have a lot of questions there. Guideline 9, which is really the one that's aimed at the multiple acquisitions. Diana addressed that too. I see it as sort of aimed at the PE firms. There's a lot in here that I think really pushes the bounds. And I think, we've seen these arguments in recent cases that the Federal Trade Commission has lost, like the Meta Within, like so far, the Microsoft Activision. We'll see what happens with the Amgen Horizon, where this leveraging theories. But I think there are the labor issues that Howard mentioned, that I had mentioned. I think there are going to continue to be losses. And the one thing I would say is that there is a danger, to me, in maintaining a broad public support for merger enforcement policies. There's a little bit of a danger that too many court losses, like reaching too far, that you're going to undercut that consensus that exists. That's so important, I think. What you want with merger guidelines is something that in general, people are going to support and understand. When you start to go too far off to the left or too far off to the right for that matter, I think that's when you kind of tend to undercut your merger enforcement policy. And I started my antitrust career at a time when there was a substantial public pushback to antitrust merger enforcement that had been occurring in the 60s and the 70s. When I started in the 80s, there was a concern that the merger enforcement policy was not allowing our Rust Belt industries at the time to recalibrate, to be able to compete against very efficient Japanese, steel mills and whatnot. There was a concern that there was an underappreciation for the non-anti-competitive reasons for transactions. And that's how I started my career. So when I look at it, the guidelines from 1982 through 2010 were really an attempt to kind of rebalance from the 60s and the 70s so that you wouldn't be basically pushing capital into a bunch of inefficient conglomerate mergers, and you would be recognizing where there were pro-competitive efficiencies and transactions. So I hope that that's where we stay. I listen to David and I listen to Aviv, and I get a lot more comfort about how things are going to be handled than I do when I'm sitting in a hotel room looking at the merger guidelines. Okay. And so I hope that in the next iteration that maybe some of the things that you've expressed here today will come through. And I hope that folks will consider some of the implications of some of the more far-reaching statements that you find in guidelines for, 8, 9, and some of the other places we don't have time to go through today.
Great, thank you. So we don't have time to follow up much on that question. Perhaps at lunch we can talk about a subject that has been alluded to, I think would be worth some more exploration, which is the whole question of vertical and other non-horizontal conglomerate mergers. The term that's still from my GE background gives me hives. But so perhaps at lunch we can explore things like the presumptions that are built into one of the guidelines on vertical mergers and whether that's consistent with the economics and the law. So the last topic for the panel, and then we'll ask the government to come back up. And I assume you'll all be willing to stay in place a little bit past 12 to hear from the people who you really came to hear from today, since they would close us off with 5 or 6 minutes of final remarks. But before we do that, last topic, we've talked about the courts, the sort of judicial future of these guidelines once they're adopted in final form. And if you look at a strain of cases the government has brought, very expressly trying to bring harder cases, more aggressive cases, succeeding in bringing them, not always succeeding in winning. And so when you look at the track record, does it tell us anything important about the future of the guideline and the future of policy? Some Democratic appointed judges have rejected government cases, some Republican appointed judges. Often they've agreed with the government's legal theory. It hasn't been about the theory, it's been about the facts and whether they accord with what the judges viewed as market realities. So with that in mind, and perhaps Howard, since he didn't get to respond to the last question, and each of you could briefly address, what's the future of the guidelines in the courts, assuming they're adopted as written today?
Right, the questions are related. I mean, in some sense, you can read these. Sorry, the questions are related. In some sense, you can read these guidelines as a long list of concerns that people have been talking about for a long time. In thinking about mergers, and that have been raised to courts. So a lot of what's in the guidelines will be familiar to the courts, some won't. I think that some of the theories that are in the that are in the guidelines, for example, nascent competitors and things like that. If you look at what happened with Meta Within, the court didn't reject the theory, basically just rejected the evidence. So I think there's a receptivity perhaps in the court to some of the theories that are going to come to bear here. I think where there won't be receptivity is where there's a perceived effort to shift historical burdens. And I think that is exactly what the agencies ran into in Microsoft Activision, United Healthcare Change, Assa Abloy Spectrum Brands. I was involved with that one, but I think that was a big part of the issue. These burden shifting issues, you can use the guidelines to socialize with the courts issues that they should be sensitive to, and that can be harms that flow from mergers. What you can't do with the guidelines is shift what judges in their broad experience hearing largely civil cases, are going to think are proper burdens, are sort of logical kinds of equitable arguments. And I think to the extent that the guidelines are seen as pushing, forward on those, they're going to meet a chilly reception. To the extent that they are viewed as sort of erring and giving fuller explication to the kinds of harms that have been raised in cases before, they can be informative to the courts and make the courts more receptive to some of those theories.
Great. Well, good. So we're more or less on time. So now, David, I don't know which order or how you want to do it. Please check the podium and wrap us up.
So I'm going to be brief. First and probably most importantly, I'd like to really thank the panelists. This is exactly what we're here for. I think, Mark, you mentioned that folks are here to hear us. We're not here to hear ourselves. We're here to actually hear everyone. And what I'd like to encourage you is to not just have kind of brief comments here, but, work through the details, send us, line edits, send us big picture comments, send us any sort of comments you have. That is exactly why we put the draft out there, is we want to hear comments. We want to get it as right as we can. Okay. One thing I can pretty much guarantee is we're not going to be able to satisfy all the comments. As you heard here, we got contradictory. So I think that's a guarantee, but we're going to try to answer as much of these as we can. Now, in terms of, there was a question as to whether these guidelines were trying to signal tougher enforcement. I think the answer is yes. If I would be saying anything different, I think I would be totally non-credible. I mean, our leadership, their views. But at the same time, we think these are fair guidelines. I'd let Dave sort of talk about whether they adhere to the law. He tells me they are, and I take his word for it. I can tell you as an economist, one of the things that we're trying to do here is to really sort of take concepts and bring them to the modern economy, where certain concepts like horizontal mergers, vertical mergers, just don't apply. I mean, you can talk about horizontal effects, vertical effects, other types of effects, but having this, kind of neat boxes where we say this merger is horizontal, therefore we can look at these guidelines. These are vertical, we could look at these guidelines. Just doesn't work. We need to sort of, that just not in the modern economy. That's just not it, right? I mean, it's maybe it worked when we had widgets and we we're producing, certain types of products. Doesn't work today, and that's a lot of what we're trying to do here. And I think that's an important part of it. I mean, even like, breaking sort of these barriers. I really appreciate actually Howard's comment on the labor market, and really sort of, even though you can think of getting philosophical, is what is a lessening competition labor markets? I think there's a really important question. I don't have time to go through it, but for years I've actually been giving examples of type of effects you might see in product markets, and trying to sort of see when is a increase in price a lessening of competition, right? So even if we stipulate this is the effect of the merger, when is a lessening competition or not? I think that's a really hard question to answer. And I'm not sure, it's purely not a purely economic question. I don't know. It's a purely legal question, and it's not one that I think we can resolve, but we'll see how far we can get. And then finally, just one comment. I think Howard was trying to tempt me to sort of commit to staying at the agency for the rest of eternity. No, I'm not going to commit to that. But I will actually say one thing. The way I see our job, and this is not a perfect analogy, but let me try to give it anyway. The way I see our job is we're out there to build a car, to build the best car that we can. Okay. But at the end of the day, we are not responsible of sort of how it actually gets driven. Okay. So you can build a perfectly good car, right? But then if it's used irresponsibly, that is not something that we can do. And that's, I think, what we're trying to build here is we're going to build a car. It's going to have a lot of features, and hopefully they will be used responsibly. So that's kind of my view on what we're doing. Let me pass it on to Dave.
Thanks, Aviv. He didn't mention this. It is an electric zero emission car. I'll be really brief too. Again, huge thanks to the panelists. Like, as Aviv said, this is exactly what we came to hear. We made it a 60-day comment period. Usually it goes out at 30, because we realized, like, we've been working for years on like 51 dense pages, and people need time to read and give us the most useful feedback. So we really look forward to that. A couple of things just to react to and like make sure that it's clear. So the 30% presumption that's in the guidelines, that's actually updating the guidelines to reflect recent practice. So unfortunately, the 2010 guidelines did not reflect the agency's practice. So in the Anthem case under the Obama administration, if you look at the complaint, 30% presumption was alleged in the national markets. In the sugar case, we alleged a 30% presumption, again, relying on that exact line from Philadelphia National Bank. And in the Penguin case, we alleged a 30% presumption. So actually putting it in the guidelines now updates them to reflect agency practice going back a number of years. I'll also mention, just going to the district court cases. So is that line from Philadelphia National Bank good law? So you will see that exact line about the 30% presumption quoted in the Energy Solutions case in 2017, in the T-Mobile Sprint case, which is named Deutsche Telekom in 2020, and in the Penguin case just last year. So just want to make that clear. On the 1800 level, which we reverted to, obviously that was in place going back to the Baxter guidelines in 82. It was in place through 2010. And on the sort of like left-right debate, the bipartisan Antitrust Modernization Commission report in 2007 recommended keeping in place the 1800 level on the presumption. So, I think that's well-founded. To Howard's point quickly about coordinated effects, that's the biggest thing the presumption is doing. It's telling you the burden shifting on coordinated effects. And one thing that, it's on the last page, but it reflects the law and it's important. There's a explicit rebuttal to a structural presumption of coordinated effects based on whether or not the market is susceptible to collusion, right? So this has always been a debate in antitrust cases. Well, this market, is it susceptible to coordination? Is it not? And the law is very clear. The Heinz case, that the expert had said, oh, you need to show that it is that coordination is susceptible in this industry in order to show a coordinated effects concern. The DC Circuit said no, that's once you have the structural presumption, you need to show why this industry is different, right? And I will acknowledge there are going to be many industries where that's going to be very relevant evidence, but that's in the rebuttal section. Okay, one other thing I'll mention. Diana mentioned that we don't cite a lot of controversial circuit cases. I have to say, like, we saw that as a feature, not a bug. And like, that's just a little bit of an explanation of what we're trying to do here. We are not trying to go find like the most pro-enforcement possible circuit case and then cite them. What we are trying to do is fairly describe the law as it's going to be applied. And I'll just finish with saying, I am sure there are situations where the comments are going to be really helpful. They're going to say like, oh, you cited, 4 different circuits that use the 1800 threshold, but like you missed these other 3 and like, here's a legal analysis. Like that's what we want to do. And so we're so excited as you think about comments to get into the question of like, is the holding in the guideline actually the good law today? Is it prevailing law in the United States today? That's the debate we really want to have, and holding by holding. So, I'll just finish with what I mentioned earlier, this law and economics distinction. We all know the cellophane fallacy. Most lawyers cite DuPont. So there's actually a paragraph in the guidelines that points out this distinction between a holding of law and the economics used to find facts in particular cases. That's another lens through which we're looking at this. And as you all are thinking about comments, we're really eager to hear that. Where we couldn't come up with a way we thought was using sound modern economics to apply a holding of law, we didn't cite it. So, we cited almost all the Supreme Court cases. We thought that's important. You won't find Vaughn's Grocery. We just couldn't find a way. But with the rest of them, what you see is our earnest effort to find a way to present modern economics using the law. Thanks.
Okay, I promised a rich, fulsome debate and discussion. That's begun. Let me ask you to now recess out the door, either to the left to an elevator down 2 floors, or walk down the stairs, grab a sandwich, talk amongst yourselves, figure out what your questions are going to be, and we'll resume in just a minute or two.